Hello?
Hello.
Hello? Hello?
Good morning, my lord.
Good morning. How are you?
I'm fine, my lord.
Yes, that is Adams, right?
Yes, my lord.
Okay, what of the other lawyers?
I just spoke with them. They say they are connecting.
Okay, they
I
are
think one
connecting.
is they are here, but they are muted. That is another thing. They may likely
And
not.
let them unmute now so that we can exchange pleasantries before we go into the main judgment.
Please unmute yourself.
Yes, let them unmute, please.
Unmute yourself, please. They are still muted. Unmute yourself. Unmute yourself. You can. We can't hear you. Good morning. You mute yourself again.
Hello? Barrister Ogaji.
They muted themselves.
Barrister Ogaji, good morning. Is it Theophilus? Udoma Theophilus. Ogaji is okay.
My lord, can I go offline and call them?
Yes, we can call them, please, so that they can
Yes,
unmute
they
themselves.
have to unmute themselves. That is the issue we are having now.
And let them unmute themselves now.
Let me call them.
Hello, sir. Good morning, sir.
Good morning.
Hello, sir.
Good morning. How are you?
Good morning, my lord.
Yes, good morning. That's is it Onoja?
This or not just Odoma.
Okay. What of the other council?
Ogaji is unavoidably absent. Like he has a matter in front of our time. I'm standing in for him.
Sorry, I'm not getting you, please. Can you come again?
Yes, sir. Ogaji is having a matter in front of our people. Currently, I'm standing for him.
Sorry, I'm referring to the other lawyer. I think you are appearing for the defendants, right, Onoja?
Yes, sir.
Okay. Who is the counsel to the claimant? Mr. Obeten, I think that's the name.
My lord, he's just calling me. I told him since, join the line. He just called now.
Okay.
And I told him that we are waiting for, or we should go ahead with the judgment.
Is that what he said?
No, I asked him whether we
allow
should
him,
go.
let him join. Allow him, let him join.
Unmute yourself.
Okay. I've been unmuted.
Thank you.
Good morning.
Mr. Obeten, are you online now?
Yes, my lord. Good morning, my lord.
Okay. Mr. Onoja, good morning too.
Good morning, my lord.
Yes. So please let the case, a registrar call up the case so that we can proceed.
The National Industrial Court of Nigeria holding at Abuja Judicial Division before his lordship, Honorable
Hello?
Justice. Hello, my lord.
Call up the case, registrar.
Yes, I'm calling it already. In the National Industrial Court of Nigeria holding at Abuja Judicial Division before his lordship, Honorable Justice E.D. Subilim, case number NICN/ABJ/78/2024 between Pastor Dominic Ode and Ambrose Kutundu and others.
Okay, parties are absent.
Yes, my lord.
The claimant is in court.
Oh, claimant is in court?
Yes, claimant is in court.
Yes, Mr. Onoja, out of the defendants.
Hello, defendant.
Hello?
Defendant is absent, man.
Okay, defendants are absent. Yes, please announce your appearances.
May it please the court.
Yes.
Often Obeten for the claimant.
Obem.
Obeten.
Okay, Ofem.
Obeten. O-B-E-T-E-N.
Okay. Yes, you appear for
the claimant.
Pardon?
For the claimant.
For the claimant.
Yes, my lord.
Yes. Pardon? Please come again.
Odoma. Theophilus.
Oduma.
Yes.
Okay.
Theophilus.
Okay.
That's my lord.
Theophilus Onoja. Eh?
Yes, my lord.
Pardon?
Yes, my lord. Onoja, my lord.
Theophilus Onoja. Okay.
For the defendant, my lord.
Yes. Mr. Onoja.
Yes, my
Please,
lord.
because of the situation we find ourselves, the cases, I mean, we you have to readopt your processes for me to read out my judgments. So just adopt your processes. Onoja,
Yes, my lord.
please readopt your processes, the
Okay,
defendant's
my lord.
processes. Mm.
Okay, my lord. The defendant is final written.
Onoja, I'm not getting. Okay, Onoja, I'm not getting you.
Yes, my lord. I see, my lord. The defendant has filed his final written.
It's like your attention is not. I'm not because the audio doesn't seem to be very clear. Speak to your speak to your system, please. Yes, can I hear you?
Yes, my lord. I said the defendant has filed his final written address.
Okay.
Yes, my lord. And this, sorry, my lord, I'm trying to get the date it was filed, my lord.
No, just go ahead. We take note. We've taken note of that.
Okay,
That at
my
least the
lord.
written address is before us. Mm.
Yes, as the court basis. My lord, we humbly adopt the final written address, my lord, as our final address in this matter.
This is a different lawyer.
Yes.
They want us to readopt.
My lord, we humbly adopt the final address, my lord.
Yes. Noted.
Thank you, my lord.
Okay. Mr. Betten.
Yes, my lord. The claimant's final written address is dated and filed the 27th day of October, 2025.
On 20 what?
27 October,
Yes.
2025.
Yes.
We adopt same as our oral submission in support of our case.
Okay. Yes. Wow. This is the judgment of the court.
As court pleases.
Court pleases.
Okay. The claimant, by a general form of complaint, dated the 5th day of March 2024, filed on the 7th day of March 2024, praised the court for the following reliefs against the defendants. 1. An order for the defendants to pay the sum of 70 million naira only to the claimant as damages for wrongful determination of service and for all the unclaimed rights and benefits during the time of engagement. 2. An order for the sum of 20 million naira only against the defendants being general and exemplary damages for neglect, conduct, and breach of duty and abandonment of claimant during medical crisis. 3, that's C, an order for the sum of 20 million naira only to be paid to the claimant due to the stigma, psychological trauma, mental torture suffered by the claimant as a result of the unwanted lies which the defendants spread against the claimant. 4, that's D. 10% interest on the judgment sum per annum from the date of the judgment to the date of final liquidation of the judgment sum. Then E, that's 5. The cost of this action assessed at 5 million naira. The first and second defendants, having been duly served with the originating processes, entered their appearances and filed their joint statement of defense, effectively joining issues with the claimant. Consequently, this matter proceeded to a full plenary trial, during which the parties laid evidence and filed written addresses in support of their respective positions, the substance of which shall be evaluated in this judgment. Now, the brief facts of the case. The facts of this case, as gleaned from the pleadings and evidence before this court, are that the claimant has been a member and clergyman within the defendant's church organization since 1996, serving in various capacities, including National Director for the Students' Wing. That in 2017, the claimant even began pioneering a new branch of the church for the defendants. Claimant stated that between 2017 and 2023, at the instance of the defendants, he was involved in non-pastoral tasks for the defendants, including land acquisition, the establishment of a palm tree plantation, and the supervision of building constructions. The claimant asserts that the defendant specifically promised to reward him handsomely, bountifully, for his technical labors, including a verbal commitment to allocate one apartment in the newly constructed building to him as compensation. The claimant claims that his engagement for the purchase of lands, the establishment of an 800 palm tree estate, and the supervision of construction projects constituted technical services under an implied employer-employee relationship or agency contract entitling him to professional remuneration. The defendants, however, state that the claimant was a volunteer who provided these services out of spiritual goodwill and missionary zeal, asserting that his admission of willingly volunteering to start the branch precludes any retrospective claim for wages. The defendants deny making any enforceable promises, contending that any such statement were vague, lacked certainty of terms, and were never reduced to writing as required by law for interest in land. The claimant also claims that while performing technical duties for the defendants, he sustained a serious head injury from a nail and further oversaw a project where a carpenter fell and became paralyzed, alleging that The defendants are liable for medical expenses and damages due to negligence and abandonment. The defendants maintain that they owe no duty of remuneration or compensation to the claimant, arguing that the lack of a formal employment bedrock or privity of contract absolves them of liability for workplace injury. Commencement of hearing. On the 12th day of November 2024, claimant opened his case by testifying for himself as claimant witness number 1. He adopted his written statement on oath, as well as his 3 witness statements on oath of 7th day of March 2024, 13th day of June 2024, and 11th day of November 2024, respectively, as his oral evidence. He tendered documents in evidence which were admitted by the court and marked as Exhibit Iegwa 1 to 6. He was cross-examined by the learned counsel to the defense. He also called one Jeremiah Anthony, a carpenter, who testified as claimant witness 2, and was cross-examined by learned defense counsel. One Reverend Agbo Martins, Black Diamond, also testified as claimant witness number 3. He equally tendered documents which were admitted by the court and marked as Exhibit Diamond 1 to 3, and was subsequently cross-examined by counsel to the defendants. One Cyril Ode, an architect, also testified for the claimant as claimant witness number 4, and tendered a document which was admitted and marked as Exhibit Ode A, and was cross-examined by the defense counsel. At this point, the claimant closed his case. On the 22nd day of May 2025, the defendant opened their case by calling 3 witnesses. The first witness was one Mr. Tamuno Iyowuna George, and he testified as defense witness number 1. He adopted his witness statement on oath. Of 31st day of May 2026. Witness on oath of 31st May 2025. 2024. As his evidence. In this case, he tendered a status report of the Church Board of Trustees, which was admitted and marked as Exhibit Judge A, and he was subsequently cross-examined by the claimant's counsel. Also, the second witness, who testified as DW2, is one Chief Emmanuel Okogbule from Imoha local government area. DW2 said he is the managing director of Royal Morgan Security Limited and was equally cross-examined by the claimant's counsel. The second defendant testified as defense witness number 3 and adopted a witness statement on oath of 8th day of November 2024 as her oral evidence. He tendered documents which were admitted and marked as Exhibit Katundu A and B. She was equally cross-examined by the claimant's counsel. The defendants afterward closed their case and court adjourned for adoption of final written addresses. I now reviewed the defendant's final written address and that of the claimant. And This is the decision of the court. Having carefully and with keen interest considered the pleadings filed by all parties, thoroughly reviewed the comprehensive written addresses, and heard the exhaustive and compelling oral arguments presented by learned counsel for all parties, this court, in the exercise of its inherent and statutory powers, has carefully distilled the following critical issues for determination. 1. Whether the claimant has established a robust legal or contractual basis sufficient to sustain the claims advanced against the defendants. 2. Whether upon a finding of such legal or contractual basis, the claimant is entitled to the relief sought in this suit, particularly concerning remuneration, compensation, or damages. This court, it is imperative to state at the outset, occupies a unique, specialized, and constitutionally entrenched position within the Nigerian legal landscape, particularly with respect to labor and employment matters. Its jurisdiction is now largely exclusive in this critical domain, encompassing inter alia the authoritative determination of contracts of employment. The foundational and exclusive jurisdiction of this court is constitutionally enshrined in Section 254C of the Constitution of the Federal Republic of Nigeria 1999 as amended by the Third Alteration Act of 2010, and further by the National Industrial Code Act of 2006. This constitutional amendment represents a landmark development, establishing the National Industrial Code as a superior court of record vested with specialized and exclusive jurisdiction over a wide and comprehensive array of labor and employment disputes. The Court of Appeal, in the case of Ayode versus Omoele, had held and affirmed that Section 254C of the 1999 Constitution as amended grants the National Industrial Code exclusive jurisdiction over all matters relating to or connected with any labor, employment, trade unions, industrial relations, and matters arising from the workplace, including conditions of service, health, safety, welfare of labor, employees, workers, and all matters incidental or connected thereto. This expansive interpretation is consistently upheld by appellate courts, leaving no scintilla of ambiguity as to the breadth and exclusivity of this court's mandate. Similarly, in the case of IBEDC PLC versus Onipade, the Court of Appeal reiterated with precision and clarity that the jurisdiction of this court extends to the absolute exclusion of any other court in civil cases and matters relating to or connected to any labor, employment, the condition of service of labor, employee, worker, and matters incidental thereto or connected therewith. This explicitly includes conditions of service such as health, safety, and welfare, which are directly and fundamentally relevant to the claims presently before this court. It is crucial to emphasize that despite its broad and exclusive jurisdiction in labor and employment matters, this court remains a court of defined subject matter jurisdiction, as definitively clarified in the case of Bisong versus University of Calabar. His jurisdiction is strictly confined to matters closely and intrinsically related to labor and employment, as clearly and exhaustively spelled out in Section 254C of the 1999 Constitution as amended. The court cannot and will not entertain any matter falling outside its constitutionally prescribed subject matter area, a principle that reinforces its specialized competence rather than diminishes its authority. Importantly, this court's jurisdiction, as enshrined in Section 7, subsection 6 of the National Industrial Code Act of 2006 and Section 254C1 F, H, and 2 of the 1999 Constitution as amended, is uniquely characterized by a constitutional and statutory mandate to apply international best practices in labor, including ratified and unratified ILO conventions and recommendations in the adjudication of labor disputes. The Constitution explicitly permits and indeed obligates this court, when adjudicating, to apply international best practices in labor and the treaties, conventions, recommendations, and protocols on labor ratified by Nigeria. This statutory mandate has been affirmed and reiterated by the Court of Appeal, His Lordship, Nimpar JCA, in the case of Ferdinand Dapa versus Stella Anyam Ode. Recognize the constitutional power of this court to rely upon and apply international conventions which have a close bearing on claims related to workplace and labor matters. Furthermore, His Lordship Ogaku JCA, in his lead judgment in Sahara Energy Resources Limited versus Mrs. Olawumi Oyebola, went a step further in interpreting Section 254C 1F and H and sub 2 of the 1999 Constitution as imposing an obligation on this court to now apply good or international best practices in adjudication. This judicial pronouncement underscores the imperative and mandatory nature of this mandate. Nowhere is the increasing influence of the ILO jurisprudence more pronounced than in litigation concerning unfair labor practices, as explicitly reflected in the manner in which Section 254C1F of the 1999 Constitution is couched. The section confers exclusive jurisdiction on this court in civil causes and matters relating to or connected with unfair labor practices or international best practices in labor, employment, and industrial relation matters. The clear and unambiguous message is that a new, progressive, and worker-centric labor jurisprudence is now firmly established in Nigeria, fundamentally different from past approaches, and all stakeholders are enjoined to embrace and adhere to this evolving legal landscape. The claimant's case, as meticulously articulated by learned counsel, posits that the Labor Act explicitly recognizes oral and implied contracts as valid and enforceable contracts of employment. It is further contended that a clear and legally significant distinction exists between voluntary pastoral work, which may be gratuitous, and professional technical services rendered personally to the defendants for their commercial and personal benefit. It is further and robustly contended that under the hallowed principle of quantum merit, the law implies an irrefutable promise to pay reasonable fees for services evidently accepted, utilized, and from which the defendant have unjustly benefited. Conversely, learned counsel to the defendant vehemently contended that the claimant's judicial admission of being a volunteer is entirely fatal to any claim for remuneration. They argued with equal force that the absence of a formal letter of appointment conclusively precludes the existence of an employer-employee relationship under the Nigerian labor law standards. Furthermore, counsel asserted that the statute of frauds requirement under any alleged oral promise. Furthermore, counsel asserted that the statute of frauds requirements under under any alleged oral promise of an apartment becomes legally unenforceable. And now consider the first issue, whether the claimant has established a legal or contractual basis to sustain the claims against the defendants. In addressing this pivotal question posed in issue 1, let me first consider whether the claimant, despite his ecclesiastical calling as a pastor, can be legally characterized as a worker or employee in the specific context of the secular services rendered, as vehemently disputed by the defendant's counsel. While it is generally true that pastors, priests, and clergy are ordained to serve in the church in a spiritual capacity and are not automatically deemed employees under the law for purely pastoral or ecclesiastical duties, as seen in the case of Reverend Dr. V.C. Iwu versus Board of Trustees of Assemblies of God of Nigeria, and the case of Reverend Deji Olaleye and another versus Incorporated Trustees of Foursquare Gospel Church. This principle is not absolute, nor is it a shield for exploitation. The court in Reverend Gideon Iheanacho versus Right Reverend Dr. Cyril Okorocha and Diocese of Owerri correctly declined jurisdiction where the dispute arose purely from internal church administration, therefore did not constitute a labor issue. However, this court recognizes that where a pastor or a clergyman is engaged under a formal or implied contract of employment with all the discernible features of a typical employment relationship, particularly for secular, commercial, or non-ecclesiastical duties, such a clergy can indeed be treated as an employee. The English Court of Appeal case of New Testament Church of God versus Stewart recognizes the distinct possibility of an employment relationship between a pastor and a church where there is direct and compelling evidence to that effect. Consequently, flowing from the foregoing, it follows that each case must be considered based on its peculiar facts and the true substantive nature of the engagement, rather than mere labels or titles. In the instant case, paragraph 9, 10, 11, 12, 13, 16, and 17 of the statement of facts compellingly demonstrate the extensive and profound level at which the defendants engage the claimant for their personal and commercial use, distinctly and obviously outside the traditional scope of spiritual or church work. While paragraphs 2E, F, G, and H of the defendant's statement of defense shows that the work was solely under the canopy of the church and that the claimant was merely a volunteer. However, the overwhelming and incontrovertible evidence before this court fundamentally contradicts this self-serving assertion. Exhibit Diamond 2, 1, and 3, being titled documents of various properties, and Exhibit Yegwa 1, comprising pictures of these properties, clearly indicate the claimant's deep and active engagement in managing these substantial assets for the defendants. The decisive point to note here is that the claimant was not engaged to preach, minister, or discharge any ecclesiastical or religious function in these specific capacities. Instead, he was engaged by the defendant in his personal capacity to carry out secular, personal, commercial, and industrial activities, including but not limited to property management, agricultural plantations, and building construction. These activities fall squarely and unambiguously within the statutory definition of industrial undertaking and agricultural undertaking under the Labour Act. The engagement was not a theological mission. It was, in its true essence, a labor engagement for the personal and commercial gain of the defendants. This distinction is legally determinative and cannot be circumvented. The claimant's priestly identity is entirely incidental to the nature of the services rendered, which is the decisive factor. Our courts consistently apply the principle that the character of an appointment is determined by the legal character of the contract, not merely the title or religious affiliation of the appointee. Accordingly, the claimant must be analyzed purely as a worker rendering secular personal services, not as a clergy in the ecclesiastical service. For these specific engagements, the defendants attempt to cloak a commercial labor relationship in religious gap. The defendants attempt to cloak a commercial labor relationship in religious gap is a deliberate and legally unsustainable mischaracterization. In determining whether a robust legal or contractual basis exists, this court has consistently and judiciously also applied a cluster of recognized and authoritative tests to ascertain the existence of an employment relationship, especially in informal or ambiguous or non-standard work arrangements, thereby prioritizing substance over form. See also the cases of Performing Rights Society versus Michel and Brooker, and Moraine versus Swinton and Pendlebury Borough Council. Citations are supplied. The first and fundamental test is the control test. As authoritatively applied in our courts, this test asks, does the engaging party control not only what the worker does, but also how he does it? The incidents of the control include the power to decide what the employee is to do, how to do it, including the time and the place to do it. In the case of Union Bank versus Ajagu, the Court of Appeal held inter alia that a servant may be defined as any person employed by another to do work for him on the terms that he, the servant, is subject to the control and direction of his employer in respect of the manner in which his work is to be done. In other words, there cannot be employment relationship without a power to command a duty to obey. In the instant case, the defendant directed the claimant across multiple, diverse, and complex domains, property management, agricultural plantations, construction, as an agent of clearing and forwarding of goods and property for the defendants, indicative of strong, pervasive, and undeniable control over the manner and execution of the work. This test is overwhelmingly satisfied by the evidence adduced by the claimant. The second test is the integration test. This test asks, was the work integrated into the employing organization or enterprise? A continuous 6-year engagement is diverse, critical, and integral function, as evidenced by the claimant's extensive activities, points to deep, undeniable, and essential organizational integration into the defendant's commercial and personal undertakings. This test, therefore, is also clearly and conclusively satisfied. The third test is the economic reality test, which seeks to answer the crucial question, was the worker economically dependent on this engagement, given the protracted duration of 6 years and the breadth, intensity, and exclusivity of the services rendered by the claimant. This test is patently and overwhelmingly satisfied. This court, in Amalgamated Union of Public Corporations, Civil Service Technical and Recreational Services Employees versus Bureau of Public Enterprises, delivered on the 27th May of 2021, and other related cases, has adopted and consistently applied this very important and equitable test to uncover the true nature of the working relationship. Beyond the case laws, the ILO Recommendation 198 of 2006 on the employment relationship also serves as an indispensable and binding reference point for this court in cases such as this. The ILO Recommendation 198 provides an indicative but non-exhaustive list of indicators of an employment relationship, which include performance of work according to employer's instructions, integration of the worker into the organization, performance of work solely or mainly for the benefit of one person, personal performance of work, performance within specific hours, work of particular duration with continuity, and requirements of the worker's availability. This court finds that virtually all these critical indicators are clearly and evidently present in the claimant's managed engagement with the defendants, thereby reinforcing the finding of an employment relationship. The point to note here is that this court has been constitutionally mandated under Section 254C1F to apply international best practices in labor and employment matters, whether ratified or not, as authoritatively affirmed in the case of Ifeato Anthony Emodi versus Diamond Bank of Nigeria. It follows, therefore, that the ILO recommendations number 198 of 2006, the employment relationship recommendation, is highly instructive, directly applicable, and binding in its application in this suit in guiding this court's determination. A close look at paragraph 9 of the ILO recommendation 198 of 2006 enshrines the landmark principle of primacy of facts, which this court is constitutionally mandated to apply. It provides thus, in quote, the determination of the existence of an employment relationship should be guided primarily by the facts relating to the performance of work and the remuneration of the worker, notwithstanding how the relationship is characterized in any contrary arrangement, contractual or otherwise, end of quote. This court has developed a robust and progressive jurisprudence that consistently prioritizes substance over form, and the undeniable reality of working relationships over technical labels or self-serving characterizations. In Catherine Erenini versus Integrated Corporate Services Limited, the court pierced the veil of formal contractual arrangements to find the true employment relationship, holding that wherever it is established that to uphold privity of contract, a worker would suffer the fate of not being able to enforce any of his or her employment rights. That is an indication that the doctrine of privity must be pierced. Similarly, in the case of James Nwabugu Ebede versus ExxonMobil Corporation and another, the court looked beyond formal labels to identify the real employment relationship. The principle is thus unambiguously established. This court will not countenance the weaponization of formal arrangement, or more egregiously, the deliberate absence thereof, to deny a worker their fundamental entitlements. Indeed, the defendant's protracted and deliberate failure to formalize the claimant's engagement over 6 years in direct contravention of clear statutory obligations only strengthens the imperative for this court to pierce through any superficial characterization and ascertain the true substance and facts of the relationship to protect the worker from exploitation. I am mindful that Section 15 of the Labor Act explicitly requires that wages be paid at the end of each period for which the contract subsists. The defendants sustained 6-year failure to pay wages, coupled with the severe injury to the person of the worker and the subsequent abandonment, constitutes a grave, continuous, and sustained unfair labor practice, attracting the full and comprehensive remedial powers of this court. The principle of unfair labor practice was also part of the innovative and progressive jurisprudence introduced into the Nigerian labor law by the Third Alteration Act of 2010. And this court has since given substantive and robust content to this principle as shown above. In the case of John Mowete versus OK Iso Kariari and Sons Nigeria Limited, this court had held thus, in quote, I find it an unfair labor practice for an employer, that's the first defendant, in that case, to fail to pay an employee, the claimant, for a continuous period of 5 months in which the employee worked, end of quote. The constitutional principle of unfair labor practice must be seen as the law's resolute attempt to denounce and remedy practices that are inherently unfair, exploitative, or unjust in the workplace. In the case of Dr. Aukadigwe Frederick Ikenna versus Dr. Olusegun Aloopa and 2 others, this court held that it is its sacred duty to prevent unfair labor practice. This, I find, is precisely one such case where this fundamental principle finds its most compelling and necessary application. That apart, the defendant's contention that the claimant was a mere volunteer and that no valid employment contract existed must be examined against the statutory definition provided by the Labor Act. Section 91(1) of the Labor Act defines a worker in the following broad and inclusive terms, in quote, worker means any person who has entered into or works under a contract with an employer, whether the contract is for manual labor or clerical work, or is expressed or implied, or oral or written, and whether it is a contract of service or a contract personally to execute any work or labor, end of quote. This definition encompasses oral and implied contracts and explicitly covers both manual labor and clerical work. The claimant's extensive engagement in property management, agricultural work, and building construction clearly constitutes manual, supervisory, and technical labor for the sort expressly protected by the Act. Furthermore, the same Section 91(1) defines contract of employment to mean, in quote, any agreement, whether oral or written, express or implied, whereby one person agrees to employ another as a worker, and that other person agrees to serve the employer as a worker, end of quote. All essential elements of this statutory definition are met when the facts in the instant case. As 1, there was an agreement, albeit oral or undeniably implied by continuous conduct. 2, one party, the defendant, agreed to engage the other, that's the claimant. 3, the claimant agreed to serve. And 4, he actually rendered extensive, continuous, and valuable services for over 6 years to the defendant. The uninterrupted 6-year period of continuous performance by the claimant constitutes irrefutable and conclusive evidence of a subsisting contract by conduct, fully satisfying the statutory definition. The evidence before this court, particularly the compelling and unchallenged testimony of claimant witness number 1 and claimant witness number 3 establishes that the claimant had performed extensive physical and managerial labor, including the management of a large-scale plantation estate and construction supervision. This task falls significantly, evidently, and clearly outside the traditional scope of spiritual or pastoral care. While the defendants contend these were gratuitous acts of missionary zeal, the law, as stated in the case of Aaron Barr versus CRBDA, recognized a contract as a promise or set of promises for which the law gives a remedy. Although in the case of N2H Heritage Limited versus Lacasera Company PLC, the court distinguishes between a mere understanding and a contract. The consistent, dedicated, and extensive performance of non-pastoral duties over 6 years with the clear and reasonable expectation of reward, supported by the community custom, testified to by claimant witness number 3, points unmistakably to the more than a mere social gratuitous engagement. The defendant's acceptance and benefit from these services create an undeniable legal obligation to remunerate. Furthermore, concerning the defendant's argument on the lack of a written document, this court reiterates with utmost clarity that under Section 91(1) of the Labour Act, a contract of employment may be oral, written, express, or implied. The courts have consistently enforced verbal and implied employment agreement where the facts overwhelmingly support such a relationship, thereby preventing employers from escaping liability through deliberate informality. The claimant asserts that the defendants specifically promised to reward him handsomely and bountifully for his technical labors, including a verbal commitment to allocate one apartment in the newly constructed building to him as compensation. The defendant denied making any enforceable promises, contending that any such statements were vague, lack certainty of terms, and were never reduced to writing as required by law for interest in land. At this juncture, it is also critically important to note that Section 7(1) of the Labour Act imposes a mandatory and non-derogable duty on the employer to furnish the worker with written particulars of employment within 3 months of engagement. As far back as 2008, the Court of Appeal in the case of Mobile Producing Nigeria Unlimited and another versus Udo Tom Udo acknowledge the mandatory duty of an employer to comply with Section 7 of the Labour Act and held that failure to do so means that the employer cannot be allowed in law to benefit from his wrongdoing due to the failure of the claimant to tender such employment contract. The court was ready to accept the oral evidence of the claimant stating how he was employed as evidence of his employment. The defendants manifestly and egregiously breached this statutory obligation by failing to issue written particulars within 3 months, and indeed throughout six plus years of continuous engagement, the defendants violated a mandatory statutory duty. The law is unambiguous and resolute. An employer cannot be permitted to take advantage of their own breach of a statutory obligation to defeat the legitimate claims of the worker. The absence of written terms does not and cannot extinguish the employment relationship. Rather, it underscores the defendant's culpability and strengthens the imperative for this court to rely on the factual matrix. To hold otherwise would be to allow the employer to escape liability by their own wrongdoing. A result no court of equity or justice will countenance. This court finds that the underlying contract of service for the extensive labor performed does not strictly require a formal deed to be recognized for the purpose of claiming remuneration or damages for negligence. The doctrine of privity, as discussed in the case of Babcock University vs. Oyeneye, the court confirmed that a contract affects the parties thereto. Here, the direct, continuous, and undeniable relationship between the claimant and the defendants in the execution of this project establishes that privity. This court is therefore satisfied that the claimant has discharged the heavy burden of proving on a balance of probabilities the existence of a relationship far exceeding that of a mere volunteer, thereby establishing a robust, undeniable, and legally sound contractual bedrock for his claims. As a direct and inevitable fallout of the conclusions drawn above, it is also critically important to consider the claimant's assertion in paragraph 25 of the statement of facts that in the course of his work for the defendant, he sustained a life-threatening injury when a nail pierced into his skull and was subsequently abandoned to his fate by the defendants. The claimant tendered Exhibit Yegwa 2, which is a vivid picture of the claimant in blood, and Exhibit Yegwa 6, a medical report issued to him by the Katampe Primary Healthcare Center in Barir Area Council of FCT Abuja. To conclusively corroborate this fact, the claimant further claims that while performing technical duties for the defendants, he oversaw a project where a carpenter fell and became paralyzed, alleging that the defendants are liable for medical expenses and damages due to their gross negligence and abandonment. The defendants, in paragraph 4 of their statement of defense, averred that they are not aware of any injury incurred by the claimant, maintaining that they owe no duty of remuneration or compensation to the claimant, arguing that the lack of a formal employment bedrock or privity of contract absolves them of liability for workplace injuries. This argument is fundamentally flawed and legally unsustainable. The law is trite, firmly established, and non-negotiable that an employer owes a non-delegable, paramount, and absolute duty to provide a safe system of work, safe equipment, a safe place of work, and competent fellow employees. In the case of Cabo Air Limited versus Mohammed, the Court of Appeal held that, in court, it is settled law that it is the duty of an employer acting personally or through his servants or agents to take reasonable care for the safety of his workmen and other employees in the course of their employment. This duty extends, in particular, to the safety of the place of work, the plant, and the machinery, and the method and conduct of work. End of quote. The claimant's severe head injury from a nail on a construction site, conclusively corroborated by Exhibit Yegwa 2 and Yegwa 6, constitutes a prima facie and compelling evidence for a fundamental and egregious failure by the defendant to discharge their paramount duty to provide a safe system of work. This court, exercising its expansive civil jurisdiction under Section 254C of the Constitution, is fully empowered and obligated to adjudicate and grant appropriate remedies for this claim in damages arising directly from the defendant's negligence and breach of statutory duty. This court having meticulously weighed all the evidence presented, carefully assessed the credibility of witnesses, finds that the claimant has successfully established that his extensive non-pastoral engagement were performed under an implied yet legally binding contract of service. The nature, duration, and scope of the work exceeded the bounds of voluntary religious service and were performed with a clear, reasonable, and legally enforceable expectation of professional remuneration. The defendant attempts to deny this relationship are a deliberate and unsuccessful attempt to evade their legal obligations. Issue number 1 is resolved decisively and entirely in favor of the claimant. This I so hold. Now we consider issue number 2, whether the claimant is entitled to the reliefs sought in this suit, particularly regarding remuneration, compensation, or damages. In considering issue 2, I need to remind myself that this court's jurisdiction to adjudicate all claims arising from the claimant's engagement is exclusive, comprehensive, and constitutionally entrenched in Section 254C1, which provide thus. I just reproduced Section 254C1 up to A, F, and K. From a comprehensive and holistic perspective, it is abundantly clear that all the claims arising in this matter, encompassing unpaid remuneration for services rendered, non-payment of promised benefits, compensation for severe workplace injury, and redress for egregious unfair labor practices, fall exclusively within the ambit of paragraphs A, F, and K of Section 254C1 of the 1999 Constitution as amended. This court is therefore fully seized of jurisdiction to grant all appropriate reliefs. The claimant claims that his engagement for the purchase of lands, the establishment of an 800 palm trees estate, and the supervision of construction projects constituted technical services under an implied employer-employee relationship or agency contract, thereby entitling him to professional remuneration. The defendants, however, states that the claimant was a volunteer who provided these services out of spiritual goodwill and missionary zeal, asserting that his admission of willingly volunteering to start the branch precludes any retrospective claim for wages. This court has already found in issue 1 that the submission by the claimant is the undeniable truth. In resolving this issue, this court reiterates the fundamental, critical, and legally determinative distinction between the claimant's spiritual duties as a pastor and the extensive secular, commercial, and technical services demonstrably performed for the defendants between 2017 to 2023. While the defendants rely on the claimant's admission of being a willing volunteer, the compelling and overwhelming evidence of claimant witness number 1 and claimant witness number 3 establishes that the scope, nature, and duration of work managing an 800 palm tree estate and supervising massive construction far exceeded the traditional boundaries of pastoral care and plainly constituted remunerable labor. The well-established and equitable principle of quantum merit is directly and forcefully applicable here, where a party has accepted and substantially benefited from services rendered. The law implies an irrefutable promise to pay a reasonable sum for those services, even in the absence of a formal, express, or written contract. The Court of Appeal, in the case of ISA vs. CGC Nigeria Limited, clearly articulated that it is trite law that where one person has expressly or impliedly requested another to render him a service without specifying any remuneration, but circumstances of the request imply that the service is to be paid for, there is an implied promise to pay a quantum merit. See also the case of Abler Construction Limited versus Questen West Africa PLC. Where no specific remuneration is agreed upon, as in the instant case, the law imposes an obligation to pay a reasonable sum, as held in the case of Olaopa versus OAU Ile-Ife. The Supreme Court held that in a contract for work done or services rendered, where no scale of remuneration is fixed or agreed upon, the law imposes an obligation to pay a reasonable sum on the basis of quantum merit. End of quote. This position was echoed by the Supreme Court in the case of Alfortrin Limited versus AG versus Attorney General of the Federation and another, where it stated thus in quote, accordingly, in a contract for work done or services rendered, where no scale of remuneration is fixed or agreed upon, the law imposes an obligation to pay a reasonable sum on the basis of quantum merit, end of quote. The defendants have been unjustly enriched by the claimants' dedicated and extensive labor for over 6 years, while the defendants correctly assert that the specific promise of an apartment being an interest in land is unenforceable in the absence of a written instrument as required by law. This legal impediment to a specific performance relief does not and cannot extinguish the claimant's fundamental and undeniable right to fair and just monetary compensation for the substantial labor and services expended and for the damages suffered. The unenforceability of the specific promise of the apartment merely dictates the form of the remedy, not the existence of the underlying right to compensation. Invoking the hallowed principle of ubi jus ibi remedium, where there is a right, there must be a remedy, as authoritatively restated in the case of Aguncha versus Ishaya, this court emphatically finds that the defendants cannot seek refuge behind the purported spiritual nature of the relationship or the absence of formal documentation to evade liability for the severe physical injuries sustained by the claimant during the execution of industrial-scale projects undertaken for their direct and substantial benefit, as held in the case of Ghost Time Motors Limited and another versus Akinremi. General damages are those which the law presumes follow from the type of wrong complained of. The claimant has suffered both significant economic loss due to unpaid remuneration and profound physical and psychological trauma as a direct consequence of the defendant's negligence and unfair labor practices. Following the guidance in MultiChoice Nigeria Limited versus Otto Miowo regarding personal injury cases, this court must assess damages to justly and adequately compensate for the pain, suffering, medical expenses, and the hazardous and exploitative environment the defendants permitted and created. Therefore, while the specific claim for the apartment as a direct transfer of land fails for want of a written deed, the claimant is undeniably and justly entitled to substantial general damages for the extensive services rendered, the profound physical injuries sustained, the attendant suffering, and the overall hardship caused by the defendant's egregious conduct. The law, in its inherent fairness and commitment to justice, will not permit the defendant to be unjustly enriched by the claimant's dedicated technical labor, and significant physical service, nor will it allow them to escape liability for their clear breaches of duty. The assessment of these damages is guided by the principle of what a reasonable man would consider fair and just compensation, as noted in the case of Nitel Trustees Limited and another versus Syndicated Investment Holdings Limited. In the NIC, that's in this code, Section 14 of the National Industrial Code Act of 2006 also empowers this court, in court, to grant either absolutely or on such terms and conditions as the court thinks just, all such remedies whatsoever as any of the parties may appear to be entitled to in respect of any legal or equitable claim properly brought forward by the court, so that as far as possible, all matters in dispute between the parties may be completely and finally determined. End of quote. This is an omnibus, expansive, and flexible remedial provision that unequivocally empowers this court uniquely to award both legal and equitable monetary remedies to ensure complete, comprehensive, and unassailable justice in all labor and employment matters. The defendant's explicit promise to reward the pastor handsomely and to give him a flat to own constitutes a clear and unequivocal acknowledgement of an obligation to remunerate the claimant for his services, thereby reinforcing the contractual nature of the engagement and the expectation of substantial reward. If these promised rewards were not delivered, or if they are deemed inadequate for over 6 years of diverse, intensive, and extensive services, this court is bound by its constitutional and statutory mandate to intervene decisively to ensure fair, just, and adequate compensation. I therefore find that the claimant is evidently entitled to the relief sought in this suit regarding remuneration, compensation, and damages, and this I so hold. Issue 2 is resolved decisively and entirely in favor of the claimant. On the whole, having considered all 2 issues for determination, meticulously evaluated the entirety of the evidence presented, and rigorously applied the relevant principles of law, statutory provisions, as well as binding judicial precedents, the case of the claimant hereby succeeds on all grounds in the terms hereinafter ordered. Accordingly, I hereby enter judgment for the claimant on the following terms. 1. An order is hereby granted for the defendants to pay the sum of 20 million naira, 20 million 80,000, 20 million 80,000 naira only to the claimant as compensation for unpaid remuneration for services rendered and for the wrongful termination of said services. 2. An order is hereby granted for the defendant to pay the sum of 10 million 40,000 naira only to the claimant as general damages, as general and exemplary damages for the defendant's breach of duty of care and unfair labor practices perpetrated against the claimant. And 4, an order for 10% interest per annum on the total judgment sum from the date of this judgment until the date of final liquidation. Judgment is accordingly hereby entered. Cost of 300,000 naira is also hereby awarded. This is the judgment of the court. Hello?
Yes, my lord.
Yes. Can I?
We thank you so much for the wonderful. Thank you, my lord.
Thank you.
Our judgments.
Thank you. Hello?
Thank my lord.
Ogaji, I'm not getting you. Speak to the...
Thank you.
Okay.
Hello, my lord.
Thank you.
Thank you for the judgment. Thank you,
Thank
sir.
you very much. Mm-hmm.
Thank you, my lord. We are
You're
grateful.
welcome. Thank you. Okay. Mr. Adams, this is the end of the case.